Hi, my name is Mark Joseph and I'm a South Florida family law attorney. And you're here to find out about the new timesharing laws in the state of Florida and the presumption of 50-50 timesharing. As I've mentioned before, as of July 1st of 2023, there was a host of changes that occurred in the state of Florida as it relates to family law matters. This includes parentage, alimony, timesharing custody, domestic violence, and a few others. In this video, we're going to discuss the changes to the timesharing statute. Otherwise, people describe as custody, but it's really termed timesharing. But before we dive into it, please like, subscribe, and hit the notification bell so you can be updated when we post new videos. So to give context, before July 1st of 2023, there was no presumption of what timesharing should be in the state of Florida. And there was technically no presumption in favor of the mother or the father in the situation. So overall, it was how the court decided to choose, or as the parties agreed. With this new change, now the starting line starts in the presumption of 50-50 timesharing. For many people, this is a great thing or a terrible thing. However, it is still a presumption. So the new Florida Statute 6113, subsection 2C, now states in relevant part, unless otherwise provided in this section or agreed to by the parties, there is a rebuttable presumption that equal timesharing of a minor child is in the best interest of the minor child. This statute goes on to state, to rebut this presumption, a party must prove by a preponderance of the evidence that equal timesharing is not in the best interest of the minor child. Another thing to note that it also states now that except when a timesharing schedule is agreed to by the parties and approved by the court must evaluate all the factors set forth in subsection 3 and make specific written findings of fact when creating or modifying a timesharing schedule. That's a lot of information, so we're going to go ahead and break that down. So you have the first part. Now we have the presumption of equal timesharing is in the best interest of the child. But it's a rebuttable presumption. And the standard to rebut that presumption is a preponderance of the evidence, which is a legal standard. So in other words, the majority of the evidence would show that it is not in the best interest of the child. Then you have that final part that was kind of snuck in, that unless it's agreed to by the parties, essentially, if the court is the one who makes the ruling as to what the timesharing schedule is supposed to be, the court's supposed to look at all the factors in subsection 3 of Florida Statute 6113 in making its determinations. And for those who are familiar with the family court or the Florida statute in general, that is approximately 19 to 20 factors that the court looks into that needs to be specific in writing as to what evidence was provided and what the court took from those factors to make its findings. We're not going to go into those factors here today. However, for those who are interested in getting a video about those specific factors, let us know in the comments and we'll make one. So, because this video is about timesharing, and timesharing is held under Florida Statute 6113, I think it's important that we discuss some other changes that's occurred within that statute that will matter in your family law case. Another change which occurred is as it relates to parental responsibility and the consent to mental health treatment. It's sort of a tweak, but before, the parenting plan that would be ratified by the court, whether it be by agreement or by ruling of the court, would have to provide that either parent may consent to the mental health treatment for the minor child. That's now changed. The statute reads in full, if the court orders that portion of 6113 subsection 2B3A now states, if the court orders shared parental responsibility over healthcare decisions, either parent may consent to mental health treatment for the child unless stated otherwise in the parenting plan. So in theory, in practice, the default is either parent may do it. However, for those, whether you be a practitioner or a person who has your own family law case, if you don't want that to be the case, you need to make sure that in the parenting plan, it specifically states otherwise. If it doesn't, then either party may consent to that treatment. Now, under Florida Statute 6113, subsection 2C2, the court shall order that the parental responsibility for a minor child be shared by both parties unless the court finds that shared parental responsibility will be detrimental to the child. But in determining detriment to the child, the court may consider evidence of domestic violence, whether either parent has or has had reasonable cause to believe that he or she or his or her minor child or children are or have been imminent danger of becoming victims of an act of domestic violence by the other parent against that parent or against the child or children whom the parents share in common, regardless of whether a cause of action has been brought or is currently pending in court. This is an interesting nuance here. So you have on one hand the detriment standard that's been established in situations in which if the court finds it, it's not going to award shared parental responsibility. But that second line that I referenced to the issue of domestic violence or an imminent risk of being in domestic violence, so to speak, that actually applies and comes out of a separate statutory change in domestic violence. This is called Grayson's Law. We'll have another video on it where we talk about it more in detail. However, the response to that change in statute actually applies here in Chapter 6113, which addresses the time sharing and the parental responsibility. The reason why I bring this up is because of this change, there's actually a change to one of those factors that I mentioned, those 19 or 20 factors. They actually have a change where that same language where it talks about that imminent harm, so to speak, that's actually embedded within those factors as well. But again, we will talk about that in a separate video that addresses the changes to the domestic violence statute. Now, for the detriment standard, there's also situations in which a rebuttable presumption does get created that shared parental responsibility is a detriment to the minor child. Some of those examples is if a parent has been convicted of a misdemeanor of the first degree or higher involving domestic violence as defined in 741.28 and Chapter 775. If a parent meets the criteria of Florida Statute 39.8061D, or a parent has been convicted of or had adjudication withheld for an offense enumerated in Florida Statute 943.0435 1H1A, and at the time of the offense, the parent was 18 years of age or older, or the victim was under 18 years of age, or the parent believed the victim to be under 18 years of age. Those are very complicated but real situations that may occur in family law cases. However, it is so extensive that we cannot go into those factors or considerations within this video. But if you are interested in hearing more about them, we would do a separate video. If you comment or reach out to us, let us know if that's something you want to see or hear about. The final point that I want to make with these changes to the time sharing as well as parental responsibility is that I think for those as a whole, even us as practitioners, as well as those who are going through the family court system, you want to understand that this shouldn't have, if at all, changed how cases were addressed. What this mainly does is it sets up for the courts specific ways and routes to address parenting issues and time sharing issues in family law cases, and basically making them show their work. So there was no policy before for or against equal time sharing, but that's where they start now. And if they're going to deviate from it, or even if they're going to stay with it, they still have to explain it via written findings. if you're going to move away from establishing or allowing for a shared parental responsibility, you have to show that there is a detriment. You have to explain that detriment. So a lot of this is to protect the public, or at least allow the public to understand as a whole what went into the decision making in a lot of their cases. Under this theory and breakdown, the courts are no longer supposed to just enter rulings without explaining them. Going through these factors, going through these considerations should hopefully allow families to not only address and understand why the court did what it did, but then there's always the concept of modifications, where later on, if there is a substantial material change in circumstances, that can be modified, or the situation or the parenting plan can be modified later. That being said, that's the summary of the changes that went into effect as of July 1st of 2023 as it relates to time sharing and parental responsibility parenting plan issues. So if you or someone you know has a family law matter that involves time sharing, parenting plan, or even just divorces in general, child support or paternity, please share this video with them. Have them like, subscribe, hit the notification bell, and have them reach out to our office. We offer free case evaluations, and provided if there's a matter that we can handle, we set consultations and we find out how we can help you. My name is Mark Joseph. Thank you for watching.